Right, good evening, everybody. Thank you for joining us. I'm Jonathan Stott of Ardent, and I'm delighted to welcome you to this joint Ardent and Town legal event. So the refusal of any CPO is a rare event, and it's safe to say that the recent refusal of a London Borough of Barking's Vicarage Field CPO has raised more than a few eyebrows. Our joint team has been through the inspector's decision with a fine-tooth comb, and we'll be presenting lessons learned from that decision from both a legal and property perspective. For those of you who may not be familiar with Ardent, we're land and property consultants specialising in land assembly for major projects. Our team includes market-leading experts in the fields of compulsory purchase and compensation, some of whom will be speaking to you tonight, as well as land referencers, landowner consultation experts, and project and consent managers. Our co-host, Town Legal, is the UK's leading boutique planning law firm. In fact, according to Planning Magazine, Town Legal has been the most highly rated planning law team in the country for the past 4 years, which is quite some achievement for a firm that's been established for less than 10 years, I think. Town has brought together and developed some of the country's leading planning lawyers, including a number of CPO specialists, who I'm delighted will be sharing their knowledge with us this evening. We, of course, recognise that we are competing with Christmas parties, the World Cup, and we've also got some pretty poor weather out there today. So the fact that we've got such a well-attended event serves to underscore the importance of and the interest in the Vicarage Field decision. In addition to the people in the room, we've also had requests from various local authorities and developers in other parts of the country who are keen to see a recording of the event. So I've been asked to make you all aware that the event is being filmed for that purpose. I'm sure you're all aware that the refusal of the CPO is a once-in-a-blue moon event. And I'd say that probably the last refusal that attracted a comparable level of attention was a Bromley by Bow CPO, which was just over a decade ago. The reasons cited in this particular case will have a range of implications for future CPOs, with various lessons to be learned about issues ranging from scheme viability to engagement with affected parties and efforts to negotiate to acquire interest by agreement. Our presenters will get into the detail on those points and more besides, and I'm hoping there will be some clear takeaways for everybody to take forward to future projects. The format of tonight's event will see us hear a number of presentations followed by a panel discussion. So Paul Arnett of Town will present to us initially, providing an overview of the Vicarage Field scheme and the inspector's decision. Raj Gupta of Town will then follow by discussing lessons learned in relation to scheme viability. My colleagues John Sayer and Rob Quaile will then set out what the inspector had to say about engagement and compensation, and we'll finish off by having a panel discussion chaired by myself, for which Mary Cook of Town will join us, along with Colin Cottage, and Raj and John will also be participating. We're intending to allow time towards the end of the event for questions from the audience, for which I understand we'll have a roving mic to ensure that questions are picked up clearly for the recording. There will, of course, be drinks and canapés afterwards. I think there are canapés. I've written that there will be canapés. Yeah, good. There will be canapés. So all of our presenters will be on hand to answer further questions after the event as well. So we hope as many of you as possible will stay around for a drink. So without any further ado, I'll invite Paul to come to the stage and kick things off. Thank you all for attending, and I hope you enjoy the evening.
Thanks, John. I've got my old school notes, not my laptop. But and thanks for such a really good turnout, actually. Given that we are, as John said, competing with the World Cup and with bad weather. So what I thought I'd do in this initial session is, before we get into the detail of viability and engagement, is look briefly at what the scheme was and to summarise the inspector's main decisions. So as you can see on the slide, a large scheme that was being brought forward by the acquiring authority, over 31,000 square metres in Barking Town Centre. The scheme is currently, what's currently there is a 1990s shopping centre, and that was described by the inspector as being gloomy and outdated and sort of ripe for redevelopment. And the Orderland was consisted of other properties as well, residential units, a hotel, and a vacant health centre. The scheme that was being brought forward, there was various iterations of that, but the CPO scheme itself was, as you'll see from that quite snazzy diagram, was proposed for 5 mixed-use towers of varying heights, up to 36 stories, 855 residential units with proposed 10% affordable housing and hotel and commercial uses as well. In terms of the leisure uses, there was a 6 to 8 screen cinema proposed and a 300-person music capacity and the usual community uses, including primary schools and health centres. And quite interestingly, this new emerging commercial use of a food hub, which I understand is going to be a sort of a mix of food types where you have restaurants, pop-ups and things like that. And it was going to be the public face of Billingsgate, Smithfield and New Spitalfields market. Scheme obviously was promoted by London Borough of Barking and Dagenham, who owned the freehold of up to 85% of the CPO orderlands, but I think that was primarily the shopping centre. There was a point around to the extent to which they own the additional land interests in the final scheme, and their sort of preferred developer backer was a wholly owned and specific purpose development vehicle, a company called Langmar Barking Limited, but they were actually wholly owned by Pinebridge Benson Elliott, who are a global private fund manager, including a real estate fund. What I've set out there on the slide, and I'll just go through it very briefly, is a timeline, because I think that's key when you come to look at the context of this, because there are some dates that really stick out here. So I won't read all the dates out, but you probably noticed that there was a 3-year period between when the CPO was made, and sorry, the resolution to make the CPO was made and when the actual CPO was made, which in our experience is a very long period of time. And I think that was, when you read the inspector's decision, that was quite key, that she was concerned about how long all these various steps were taking, and what uncertainty that created for persons with an interest in land affected by the CPO. And also, I think the March 2021 date for the indemnity agreement, that's quite late, isn't it? Only a few months before the CPO was made. And I suspect that may have hamstrung quite a lot the negotiations that were taking place with the various landowners. There was also quite a lot of opposition, as you can see. When the CPO opened, there were 67 remaining objectors, which in my experience is quite a lot of opposition for a scheme, and only 65. So only 2, they only managed to pick off 2 objectors during the inquiry itself. So high level of opposition to the scheme. But there were certain core objectors, which I've set out on the slide there. So there was Mr. Ali, who owned those collection properties in Station Parade, obviously NHS Property Services, and then also 13 to 15 Ripple Road. And they were all, interestingly, represented by experts, sort of council. So David Elvin represented the Station Parade objectors, Chris Young represented the NHS, and Richard Moore's Ripple Road. So they were all very well represented, which is perhaps quite unusual for objectors, and they were really able to interrogate the inquiry authority's justification for the particular scheme. I've just summarised very briefly what the main grounds of objection were, and we'll obviously unpick those as the evening goes on. But first and foremost was the funding and viability of the scheme, absolutely crucial. And Raj is going to sort of talk to that in more detail later on. And then secondly, probably the main headline was the inadequate attempts in the inspector's view to acquire the relevant interest by agreement. And in relation to impediments, I think particularly key was the fact that only, I think, 1 or 2 reserved matters approvals have been applied for, and yet the permission, which had been granted in 2017 in outline, was due to expire in April 2023. So the inspector was quite rightly significantly concerned about there was a huge amount of work to do in a short period of time. Otherwise, the permission would lapse. And then the usual sort of arguments brought forward that there was, taking that all into account, that there was no overall compelling case, which, as we know, is the key overarching test. Again, I'll briefly whip through this, but I thought it was useful to, we're going to touch on things that were sort of fatal to the CPO, but actually there was a lot of good things that the acquiring authority did, and their case found quite a lot of favour of the inspector. So what I've sought to do here is to set out some of the main conclusions on some of the positive aspects. So looking at, there was clear planning policy support. It had outline planning permission. There was an area action plan in relation to the adopted policy which supported the scheme coming forward, and it was also proposed to be allocated in the emerging local plan. So the inspector was clear that there was the sufficient planning policy support, and equally looking at the need for the CPO, the inspector was convinced that there was, in her words, an obvious and desperate need to regenerate the town centre. Equally convinced that there was significant environmental, social and economic benefits deriving from the scheme. So that all these are conclusions which would make you think that the CPO was going to be confirmed. And she was convinced that there was an extremely compelling case for the acquisition of Orderland. So I think she was very keen on the scheme and many aspects of it. And also she rejected the alternative proposals put forward by the various objectors for delivering the whole or part of the same scheme or an alternative scheme. She wasn't satisfied that they would achieve the same benefits that the scheme would present. And then sort of very briefly, she was satisfied on both a human rights perspective and quality perspective that the CPO was satisfactory. Turning briefly to the conclusions which ultimately led to the refusal of the CPO, and again we'll unpick what that means in the later sessions, but she was not satisfied that there was tangible and substantive evidence presented that the scheme was financially viable and deliverable. And I think if there was the main conclusion, that probably was it. That there wasn't an updated viability assessment, and indeed I think viability only came to the fore during the inquiry when raised by the objectors. And therefore she was not able to conclude applying the CPO guidance. And just very briefly, one point that came through the decision was that the inspector was really homing in on the guidance in the CPO guidance, which is the government's national guidance, and was really using it as a sort of checklist on various points. So she was not satisfied that there was a reasonable prospect of the scheme being delivered. And as I've touched on before, she recognised there was a whole lot of work needed to be done to apply for reserved matters before the April 2023 deadline. And then, as John and Rob are going to sort of touch on in more detail, she was also not persuaded that reasonable attempts have been made to acquire the relevant land interest by agreement. And again, referring to the CPO guidance, she looked at the checklist of factors that or recommendations which the government has issued for engagement with objectors, and that's reinforcing the principle for full information, appointment of a specific case manager, keeping delays to a minimum. And again, she pointed to that 3-year period, which I think is quite telling between the resolution and when the CPO was made, and offering advice and assistance at an early stage to affected persons. So that feeds into your relocation strategy. And quite a key point was the lack of a not before date, which I think is a good point. So, if you're a person affected by CPO, you want to know the earliest date on, you won't require your property before a certain date. And that seemed to be missing, that there wasn't that assurance. And so there's just a lot of uncertainty for businesses and landowners when their land would ultimately be needed. And I've set out there that sort of the overall conclusion. So I think it was quite finely balanced, actually, the decision, but she was unable to confirm it, given the primarily the viability concerns and concerns around lack of engagement. Before I hand over to Raj, just very briefly, some initial thoughts, but we will develop that in the sessions and the panel sessions. So obviously lots to learn from the decision. That's why hopefully you're all here tonight. Just as an aside, I don't think decisions like this should be delegated to inspectors. That wasn't, I don't think, the intention of the reform. So that means that whereas before decisions used to be made by the Secretary of State on recommendation from an inspector, but in practice, I think nearly all decisions, if not all decisions, are delegated. I would question this decision given its implications for viability, given the number of objectors. Should this not have been a Secretary of State decision? And it's surprising, if I was acting for the objectors, ultimately they succeeded, but I might have been asking Secretary of State to sort of recover it. I think it's, despite the outcome, I think it's actually helpful for acquiring authorities, because I think it does clarify what you need to have in place to bring forward a CPO. And And again, we'll unpack that more as the evening goes on. But I don't think it should deter you from proactively using CPO powers. But I think it does reinforce the need, as I've put on the slide, to de-risk your schemes from an early stage, to be clear on your case and your justification for your CPO in your statement of reasons and throughout inquiry. And, you know, I think it's pretty crucial on the negotiation point is to have at an early stage an effective and robust land assembly and relocation strategist. I've put there that's a sort of personal request. I think this decision would merit updates to the CPO guidance, which I think are due in any event when the levelling up CPO measures are enacted. And I think the government could have a look again at the guidance on viability and deliverability of the CPO scheme. Is it clear enough? And how does it interrelate with the guidance in the PPG, which relates to affordable housing? And also in relation to attempts to acquire by agreement. We'll discuss it further as evening goes on, but did the inspector slightly gold plate those requirements, discuss, you know, what does an inquiry authority need to do? Could the guidance be clearer on that? And then just very finally, just as a passing thought, if and it's a big if the LERB measures are enacted, then there is this proposal, which I think is quite an important one for CPOs to be able to be confirmed on a conditional basis. And that may have saved the inquiring authority here, because conceivably the CPO could have been confirmed subject to a condition requiring the viability of the scheme to be demonstrated. Whether that's a good or bad thing, discuss, but that may have saved this particular CPO. So they're my just a sort of initial scene setting thoughts. I'm going to hand over now to Raj, who's going to discuss in further detail about the sort of viability implications of the decision.
Thanks, Paul. So I thought I'd start with a quick reminder of three main tests for the confirmation of the CPO, because it's useful to get these in perspective. It's fundamentally what we're testing with the Vicarage Field decision. So firstly, there has to be a compelling case in the public interest for the CPO. The public benefits of the scheme must outweigh the interference with the human right to own and occupy your property free of interference from the state. And the scheme must also deliver social, economic and environmental benefits. And as Paul's just outlined, the Vicarage Field scheme couldn't pass that test really in flying colours, according to the inspector. It was transformative, and the case in the public interest for it was very compelling. I think she said, or extremely compelling even. Secondly, compulsory purchase should be a last resort following negotiations to acquire by private treaty with landowners and occupiers. And of course, John and Rob will be speaking to that in a moment. And finally, there must not be any material impediments to the CPO scheme coming forward. So it must either have planning permission or be acceptable in planning policy terms. And crucially, in the subject of my talk, it must be deliverable from a financial point of view. There's no point in having a CPO for a scheme that nobody's going to build. So I thought it'd be quite helpful to sort of contrast and compare the guidance on viability in the planning field with that in the CPO field. In planning, viability should inform development plan policy, including its requirements for planning obligations such as affordable housing and infrastructure provision. Where a planning application is made, it must be assumed that the underlying development is viable, unless the applicant requires or requests that non-compliant obligations are imposed, in which case he will need to submit a viability assessment to justify that request. And there's some pretty detailed guidance on this from the government. It requires that the assessment and the underlying assumptions are transparent, and the policy sets out a number of standardised inputs, including that the development must deliver a profit on cost of 15 to 20%. By comparison, the guidance on viability in CPO, so it's a much more macro level. It simply says that the acquiring authority should be able to show the scheme is viable, or that funding is or will be available. There's no obligation to provide any kind of viability assessment or any indication of how an assessment should be presented if it is presented at all. And as you can see from the quote on the side, it seems that yeah, even if there is uncertainty about unviability, that could be acceptable if there are other compelling grounds for compulsory purchase. I really find the guidance a bit mystifying in this respect. If a scheme is not deliverable, there's no point in powers being granted. So why are you putting it on objective landowners to object and negotiate with you if you're never going to be able to deliver the scheme? So just moving on to the Vicarage Field decision itself, the inspector considered funding in two main parts. Firstly, she wanted to look at whether there was sufficient funding to pay compensation to landowners and occupiers following compulsory purchase. That's really a minimum requirement. The developer said that it had already spent about £40 million on acquisition, largely in the shopping centre, paying off lessees and putting in short-term tenancies or break clauses, and it allocated 20 million more for the remainder of the land. And that was informed by a property cost estimate maintained by the council's surveyors, but it was conceded that the estimate didn't include any provision for compensation for business extinguishment. The reasons given for this were that it was anticipated that most businesses would be able to relocate and therefore wouldn't extinguish. And also that it was hard to estimate extinguishment compensation without information from the relevant businesses themselves. If extinguishment was payable, then there was a contingency for that. The inspector wasn't convinced by this. She wasn't that impressed by the authority's relocation strategy, and I suspect Rob and John will touch on that. And given Barking's high occupancy rates, it seemed probable that some businesses were going to have to extinguish. They wouldn't be able to find alternative premises to relocate to. And the inspector also did record her concern that the property cost estimate had no provision for extinguishment costs. More fundamental was the question of, more fundamental was the question of whether the scheme was actually deliverable or that anybody would want to deliver it. The real issue was that a viability review by DS2 submitted with the planning application in 2016 had found the scheme was substantially unviable. Although DS2 hoped that it would become viable if sale prices in the area increased as much as they hoped they would. I think 62% was the figure needed to secure at least a minimum return in terms of profit on development. The developer refused to provide an updated assessment, so all we had was this 2016 viability assessment. And the reasons for that was the developer said that it was confidential commercial, didn't want to give their competitors any kind of insights into how they ascertained whether to develop or not. And the developer also said that it would be useless to produce one anyway because they assess viability in a very different manner to the usual RICS Red Book approach. They also refused a suggestion by David Alvin KC, one of the representatives of one of the objectors, that the confidentiality could be secured by an independent review of an assessment carried out under a non-disclosure agreement. I don't think that's a particularly good suggestion. That seems to be delegating the decision making to an unappointed expert who wouldn't be subject to any kind of cross-examination or questioning. The authority themselves argued that there was they're in a chicken and egg situation. Barking was convinced that the scheme would render itself viable by increasing local land prices purely because of the quality of the development. It doesn't look like a really high quality development. It just needs to get started. That would push up the prices, and then it would become viable. And the inspector had some sympathy with the dilemma, but ultimately, given that the only appraisal available to her showed that the scheme was unviable, and in the absence of any clear funding arrangements, she concluded that she wasn't satisfied that the scheme would be delivered. So before I hand on to John and Rob, like Paul, I just wanted to get a few views in about the implications of the decision. I think a lot of schemes, retail-led ones in particular, have got away with it really in the past, and they've not had to demonstrate viability. Either objectors haven't raised it, or inspectors haven't really focused in on it, and they've not really, they've been able to rely on hope, and I'm afraid that has led to some pretty poor developments in the past. Probably the most famous one is the huge hole in Bradford, which a major developer got funding as far as demolition, but not to construct. I think that's now resolved, but for many years Bradford just had a huge hole in the middle of the town. Similarly, Dartford, lots of boarded up shops where leases were acquired, but the Tesco's didn't come forward ultimately with the development. And there are others which haven't had such disastrous consequences on town centres, but having gone through, spent a lot of money in getting permission, getting CPOs, have faltered at the point of implementation. I think that's not going to happen in the future. I think this decision is going to mean that any half-well advised objector is going to raise viability, and in the current economic climate, with retail values so low and construction costs escalating all the time, it's hard to see there's going to be much activity in terms of town centre regen CPOs for some time, unless public funding becomes available for it. Estate renewal schemes are, of course, often dependent on public sector funding, but they're not really aligned to planning or CPO, and often they come with conditions attached as to when you've got to stick a spade in the ground to implement the scheme, and it's going to be done pretty quickly. And I think that causes some problems, particularly with the CPO, where you really ought to be spending some time negotiating with people, but authorities are being pushed into rushing through CPOs in order to meet funding requirements, and that really is the tail wagging the dog in many ways. One way around viability issues would be for private sector developers to commit to implementation if the CPO is secured in their CPO indemnity agreement. In other words, to proceed with the scheme without assessing its viability. And just saying that makes you realise how unlikely that is. Developers test viability for their development, CPO or non-CPO, at every stage. So I don't think that's going to happen, except in a few very specific schemes where they're on a phase and they've already effectively established that they want to go ahead. As Paul said, we're due an update on CPO guidance, presumably once the Levelling Up and Regeneration Bill, I say once, if the bill's enacted. Who knows, there's a battle going on between the government on one side and the pro-growth coalition and the anti-growth coalitions on the other. So we don't know. I think today there's meant to be a vote that's had to be postponed due to backbench amendments. So we'll see if Labour ever actually gets on the statute books. Whether it does or not, I think the CPO guidance really does need to be updated. It's just too ambiguous at the moment. Most of it's very, very sound, but it's not clear. It very much is guidance, which leaves promoters not quite sure what's obligatory and what's just good practice. If the guidance requires a viability assessment to be transparent, which surely they're going to have to be, if they are in planning, if you have to publish your viability assessment and show it on an open book basis to the world at large in order to get affordable housing requirements reduced. Surely you should have to, if you're going to acquire somebody's property compulsorily. And if they are going to be transparent, that means the inputs must be transparent as well, including the property costs. Property cost estimates, for obvious reasons, aren't disclosed to inquiries because that would inform post-acquisition negotiation strategies by claimants. And compensation is not supposed to be a matter for CPO inquiries. But if viability is marginal in the schemes, you can easily see property cost estimates being challenged in an inquiry process, and promoters being obliged to show them. I suspect you get around them by showing ranges and so on. But certainly that could be problematic and would require some adoption of existing practices. Finally, as Paul mentioned, LERB does include potential for CPOs to be made subject to conditions. I think that could be helpful where you've got a very clear yes or no event, like is funding going to be granted? Is your application for funding going to be approved? If it is in the next year, then your CPO can go through. Otherwise, it can't. I don't think it's going to work for viability itself because that needs proper consideration, and you effectively have to rerun the inquiry in some form or other. Okay, that's enough from me. So I'm going to pass you on to John and Rob. I think I've got to give you a mic. So.
I should probably check my mic's working first. We're doing a bit of an in-action swap. Is it working, Mark? I almost I've worked with John Sayer so much now. I've almost just answered to John and Rob, but I'm Rob Quaile. Move on to, we put ourselves on the same slide as well. But I'm Rob Quaile. I'm a director in the regeneration and development team at Ardent. It's lovely to see you all here tonight on a Monday night. And thank you to Paul and Raj for those brilliant first talks. They're very interesting. So as Paul and Raj both mentioned, we're now going to move on to a different aspect, which I guess is bread and butter of the work that John and I do, and other surveyors in this room, and that's stakeholder engagement and negotiation. So in her decision to refuse the CPO, the inspector stated, and I quote, and it's on the slide, based on the evidence before me and having regard to the CPO guidance, I'm not persuaded that the acquiring authority has genuinely attempted to negotiate with the affected parties. So the first question to consider in this regard, and it's been mentioned during previous talks, is what is the CPO guidance that we're referring to, and what does it require of promoting authorities in respect of stakeholder engagement and negotiation? Well, firstly, the guidance referred to is Deluxe guidance on compulsory purchase process and the Critchell Down rules. This government guidance document sets out what is expected of a promoting authority in respect of justifying, promoting and implementing a CPO, as well as on assessing compensation. There are a few fundamental concepts that sit at the heart of the sections within the guidance that relate to stakeholder engagement and negotiation. Firstly, CPO, as we've mentioned, is a measure of last resort. Secondly, this does not mean that promoting the CPO process should necessarily be delayed. Thirdly, we should be continually mindful of the fact that compulsory purchase powers interfere with human rights. There are 4 key sections within the CPO guidance that specifically detail what is expected of a promoting authority when engaging and negotiating with stakeholders. So I'll run through these in order. In general, the guidance notes that compulsory purchase powers should be used when there is a compelling case in the public interest, as Raj mentioned, and it is expedient to utilize these powers. From an engagement and negotiation point of view, it is expected that the acquiring authority can demonstrate that they have taken reasonable steps to acquire all of the land and rights included in the order by agreement. Where voluntary agreements are entered into to acquire land, these offers should therefore include the compensation that would be payable had the interest been acquired using compulsory powers. that the process of engaging and negotiating to acquire the land and rights required for the scheme by agreement should be ongoing. This includes up to and after the submission of an order, and even during the inquiry itself. Attempts to voluntarily agree should also include offers of alternative dispute resolution, ADR, including access to a suitably qualified independent third party throughout the CPO process. Helpfully this year, the RICS established its compulsory purchase disputes ADR service, which should encourage attempts to resolve disputes in this way. Although CPO, as I've mentioned, is a measure of last resort for land assembly, the guidance sets out that it may be sensible to promote an order in parallel with attempting to acquire land and rights by agreement. This is because significant time will be lost if the process is only commenced once it is clear that negotiations have stalled or failed. Promoting a CPO process in tandem can also lead to more fruitful early acquisition negotiations, as it makes the authority's intentions clear and therefore those negotiations more meaningful. Importantly, the guidance makes clear that the officer's report seeking authorization for the CPO should address human rights issues. We must be mindful that compulsory purchase interferes with human rights, so the purposes should be justifiable and stakeholders should be treated with openness, honesty, and respect. Next, the government guidance sets out what acquiring authorities should consider when offering compensation in advance of the CPO. So in order to reach early settlements, organisations should make reasonable initial offers and engage constructively with claimants about issues arising from the proposed compulsory acquisition, such as relocation and mitigation. For public sector organisations, early agreements will of course need to consider value for money in the normal way. However, promoting authorities can take into account the broader costs of the CPO process and what holistic savings there might be arising from an early acquisition. For example, a private treaty deal in advance of an order being made might include savings in respect of legal fees, both regarding promoting the order and for dealing with objectors and claims, wider CPO process costs such as staff resources, the overall cost of project delay, for example, due to the delay in access to land, and any other reasonable linked costs. As I've previously mentioned, the guidance encourages undertaking negotiations in parallel with preparing and making a CPO, as it can help build a good working relationship with impacted landowners. This can save time in the longer term by treating interest owners openly with honesty and respect. It will also reduce uncertainty and misunderstanding by making the intentions of the promoting authority clear at an early stage. Engagement with stakeholders through the process will also assist the acquiring authority to understand more about the land it seeks to acquire, any physical or legal impediments to that land, and any impediments to the development that might exist. It might also help in identifying what measures can be taken to mitigate the effects of the scheme, both on landowners and on neighbours, which can reduce the cost and ultimately the interference of the project. Acquiring authorities are expected to provide evidence that meaningful attempts at negotiation have been genuinely attempted wherever possible. In practice, this might entail keeping an up-to-date engagement tracker with details of all interactions with landowners, including any offers that have been made. So in addition to fair and reasonable engagement and negotiation, what other steps does the guidance suggest should be considered to help those affected by CPO? There is a growing awareness and focus on the uncertainty and anxiety that can be caused by compulsory purchase proposals, both for owners and occupiers of that affected land. CPO guidance therefore encourages acquiring authorities to consider the following options. Provide full and accessible information from the outset about what the compulsory purchase process involves, the rights and duties of those affected, and an indicative timetable of events. This can help stakeholders plan and reduce the fear of the unknown. Appoint a specified case manager that stakeholders can directly and easily access. This will help provide a feeling of personal engagement and ensures that the concerns of impacted stakeholders will be heard and recorded. This will help build trust, develop positive relationships, and will ensure consistency of tone and message throughout the process. Mitigate the uncertainty period and mental health impact by keeping any delay to a minimum, by completing the statutory process as quickly and accurately as possible. The prospect of compulsory acquisition is incredibly stressful and has been associated with causing and exacerbating mental health conditions. The importance of empathizing and recognizing when affected parties are struggling really cannot be overstated. We must all stand in their shoes and treat them as we would wish to be treated ourselves. Alleviate concerns about compensation by entering into agreements about the minimum level of compensation payable, such as through a land tribunal contract. This can give clarity in respect of the minimum funds that will be payable to a landowner and will provide some comfort and certainty with a mechanism to refer to the matter if the final compensation level cannot be agreed. Acquiring authorities are not obliged to secure replacement properties for affected parties or even to advise on how they might relocate. However, there is an increasing expectation that a relocation strategy should be in place to set out how affected parties might be supported. This might include providing information to occupiers on available relocation properties in the area to help mitigate landowner and business impact, or undertaking to reimburse agent fees for relocation searches. Where possible, provide a not before date, confirming that the acquisition will not take place before a certain time, and share program information, including any delays that we're aware of. This significantly helps landowners feel informed and treated fairly. It will also give the opportunity to plan business and personal affairs and to give the best chance to complete a search for relocation properties. Consider funding landowners reasonable costs of negotiation or other costs and expenses likely to be incurred in advance of the process of acquisition. Again, there is no statutory requirement to do so prior to powers being granted. However, reimbursing these costs encourages landowners to come to the negotiation table and enables genuine attempts to engage and assemble land voluntarily. In practice, we can provide this clarity by producing a professional fees policy that sets out the circumstances and levels of fees that will be reimbursed. So I hope this gives a helpful overview of what is expected from promoting authorities in terms of stakeholder engagement and negotiation prior to the grant of compulsory purchase powers. I'll now pass over to my colleague, John Sayer, to add some flavour to what we discussed, specifically in relation to Vicarage Field CPO and the inspector's decision. Thank you.
Thanks very much, Rob, and good evening, everybody. What I've done for the sort of the next session is considered what Rob's talked about in terms of the CPO guidance, had a bit of a sort of digest of both the inspector's report. I've had a look through the proof of evidence that was put forward by the council and developer surveyors, Avis and Young, and also had a look at some of the objectors' proofs of evidence and tried to sort of cross-compare actually what Rob's talked through about what appears to have happened and some of the things that perhaps don't appear to have happened. On one point I wanted to make a little bit of a distinction, and it'll become relevant a little bit later on, is in terms of the way the land ownership was made up. Is there was the if you like, the core of the shopping centre, which had the council as a freeholder. A long leasehold interest was held by the developer, and then beneath that there was a sort of a multitude of individual occupational interests. So already in this situation, the developer had a sort of contractual arrangement with a number of the affected parties. In addition to that, there was also a number of properties on the periphery of that where the freehold needed to be acquired, and there was various leasehold interests in there as well. So there was very much a sort of two quite distinct categories of people to deal with. Rewinding back to sort of some of the chronology that Paul mentioned earlier, my understanding is that some of the landowners were contacted back in 2015, and then there was a little bit of a push sort of beyond that from late 2015 to get into some discussion and engagement. It's a little bit unclear in the proofs of evidence exactly how many people that was, but there is then another sort of marker in the sand that in January 2018 all the affected parties were written to and setting out an intention to acquire property. But interestingly, it was noted that there wasn't actually an indication that CPO powers were likely to be used at that time, and what the sort of implications of that could be, which is a little bit curious, given that the first resolution to make the CPO was actually in March 2018. So when those letters would have been going out to affected parties, those within the developer and council team will be doing so very much in the knowledge of a build up to that resolution, but perhaps not making it clear to affected parties what that intention was. And certainly the inspector, she made a criticism of the fact that those sort of the impact of that and the rights and the duties of a CPO weren't actually, if you like, made clear and spelt out to people at that point. Fast forward a little bit further on, and what the inspector also noted was that it was only 10 days before the CPO was actually made that a detailed letter was sent out to all of the affected parties saying that CPO powers would be used, and the inspector was quite unhappy about this, that that wasn't really sort of made quite clear until very sort of late in that process. I think it's already been touched upon earlier, but there's clearly been criticism from the inspector about the land assembly process, and particularly about the length of this as well, talking about early discussions in 2015, and this scheme didn't get into a public inquiry into 2022, and the sort of various reasons that the acquiring authority have cited that caused delay, such as COVID and other things like that, which the inspector wasn't particularly comfortable with accepting as a sound rationale for that. There was also the fact that there seemed to be multiple different agents who were involved in the negotiating team, and there's always quite clear and noted that it's helpful for people to have very much a individual designated case officer for them to deal with, be their point of contact and to negotiate with, and it feels as if there was a big sort of group of people who were involved in this, and that perhaps created some confusion a little bit on along the way. Going back to the point about the sort of the multiple types of category of property owner, it is noted that there was a strong level of success when negotiating vacant possession with the shopping centre tenants themselves. I think at the time of the public inquiry, there were only actually 3 lessees where it hadn't been possible to either negotiate some kind of developer-friendly agreement. I think from my personal experience, certainly during the COVID period, there was a lot of enthusiasm on some of the schemes that I've been working on for some of the tenants to want to negotiate flexibility, whether that's a reduced level of rent. They want flexibility because they perhaps don't want a traditional 10-15 year commitment. So from my own experience, I know that sort of COVID period was a bit of a catalyst for those kinds of deals to be done. I think one of the key things that really sort of stands out to me about the attempts to negotiate is when you look at the opening point of the public inquiry, they had 67 objectors. 4 of those were non-stat, so people who didn't necessarily have an interest in land. So that left you with 63 objectors at that point, most of which in the documents relating to the inquiry, the acquiring authority was saying, well, we're happy to have ongoing discussion and negotiation with them. So there was effectively sort of 60 odd property owners, occupiers sitting in there that were where the acquiring authority developer needed to reach some kind of agreement or use CPO powers. looking through the evidence from the acquiring authority, what it appeared was that they, during that sort of 2015 to 2022 period, they'd actually only managed to acquire the freehold interest of one property and 2 leasehold interests within that property itself as well. So you're sort of looking at this and thinking, well, you've got a 7-year period in which you're saying that you've been active. You've got sort of 60 odd land acquisition deals to do, and it appears that actually you've potentially only done 1 freehold and 2 leaseholds. So it doesn't really create this sense that there was a very, very strong and effective negotiating strategy to actually achieve vacant possession. I think the inspector noted it was a very limited track record of private treaty deals. So in her decision, she noted absence, and this sort of picks up some of the points that Rob made earlier. That there wasn't really a clear acquisition strategy from the outset, and certainly many of the projects that I'm involved in from a very, very early stage, usually often right back at the early resolution, you'll be looking to get that acquisition strategy in place so that you're very, very clear in terms of the parties you're going to engage with, how you're going to do this, what the conduct is, and also from a home team perspective, really, really helpful to be able to set out a roadmap in terms of what you want to do and how you want to achieve that vacant possession. She talked about the messaging when the land would be needed and the uncertainty that it created for business occupiers. And that's something as CPO practitioners we hear again and again and again. It's about creating that level of certainty, understanding in the time frame by which people might have to relocate, because that helps them plan their business and ultimately can often be quite helpful to mitigate compensation claims further down the line. There's also comments in there from the inspector about a relocation strategy, which often goes very much sort of hand in glove with the acquisition strategy. That's a slightly interesting document in that it was submitted to the public inquiry partway through, and the tone of the document suggests that it was actually written post the CPO made, because it actually refers back to, we've made a CPO and this is what we've been doing. And it has a certain tone about it in terms of looking at trying to sort of add justification in terms of the work that the acquiring authorities team has done. And then perhaps some of those activities about how businesses could be supported is quite a limited section towards the back. Again, we would expect certainly on schemes that we're involved in that would be something that you would have in place from a very, very early stage. Also, the inspector was critical about that point about the rights, the entitlement to compensation, albeit it is noted that very, very helpfully there does seem to have been strong dialogue about putting fee commitments in place to enable those early engagements, but for whatever reason that hasn't converted into early acquisitions. The not less than point that the inspector also raised was that it's often very, very beneficial from a business planning perspective if someone is able to have some kind of either contractual arrangement or some kind of early assurance that gives them a guarantee or commitment that come the point of acquisition, they know that they have a minimum amount to spend potentially on their relocation or acquiring other property. But she was very, very clear that there was a real absence of frequent and persistent attempts by the acquiring authority to negotiate. So it's all quite a sort of a difficult sort of tale to hear, really. In summing up at the part of her conclusion, really, she said the efforts to acquire the CPO lands by private treaty have been largely ineffective. Claims have been made by objectors that financial offers have not been market value. There has also been limited efforts to relocate those affected by the CPO. And not before date has been absent, and this has resulted in many unable to deliver business plans and living in limbo for a long period of time. So the inspector was quite critical, really, although the acquiring authority set out this many years of negotiations. She was very, very critical in terms of how that had played out by the time it got to public inquiry. So there's quite a lot of information in there in terms of some of the background that we've heard. talked a little bit about some of the inspector's observations in there, but I think probably critically what many of us are here this evening is actually to understand a little bit more about our points of view in terms of what does this actually mean going forward. So I'm going to hand back over to John Stott, and we're going to have a bit further discussion about that.
Thanks, John. I've got to say, just from a personal point of view, I think that last point on John's last slide around the effect of the threat of CPO and people living in limbo, and I think Paul mentioned earlier that the reference to putting ourselves in the shoes of affected parties. I think, you know, whatever we're doing in the world of CPO, whoever we're representing, I think it's something we should always look to do, because it is bloody stressful for people. There's no doubt about it. The CPA are starting to do some really good work around that, and I think, you know, from my point of view, it's no bad thing that some of these points have been made. Yes, perhaps the tests have been applied in a way that maybe they haven't been previously, but is it a bad thing? I'm not sure that it necessarily is. So just an aside from my perspective. Conscious of time, and we're probably about 10 minutes sort of over where we wanted to be, but really good presentation. So thank you very much for all of those. Conscious that Mary and Colin haven't had a chance to speak just yet, but an obvious first question perhaps for Mary around what we think the decision means in terms of the potential for greater scrutiny of viability assessments. I mean, it seems fairly obvious that will be a concern for acquiring authorities. Aside from not relying on a 5-year-old viability assessment, what sort of steps do you think that acquiring authorities can take?
Thank you very much. And yes, I agree. Excellent presentations, all very helpful. I don't find this decision remotely surprising. I would like to just draw attention to the fact that there was a planning permission in 2011, which had been allowed to lapse, and that the permission underlying this CPO came about in 2018, and that at the time, the viability demonstrated, and the council had their own viability assessment, as Raj has pointed out. GVA in 2016 was saying the scheme is 42 million down on the existing use value. I would have expected a council being asked to use their CPO powers. I would have expected the council to say to the developer, what's the viability case? Why on earth would the council want to make a CPO on a scheme which they knew to be unviable? So I don't actually find this surprising. And I think that the message is, if you are either a council promoting your own CPO on your own land, and for example, you are also going to be building that out using a regen company that you've established, or you're a private developer and you want to ask the council to exercise their CPO powers, the council should be asking questions about viability. So, you know, I don't find it surprising. And I actually don't think that even if the LERB clause allowing for conditional confirmation of CPO were in fact enacted, I don't see that as any answer to this, because the inspector had to be satisfied that there was a compelling case. She wasn't. And one of the key reasons why she wasn't was because she didn't think it was going to happen on a balance. And my understanding of the powers that are coming in is that they, and I've just been reading what the select committee had to say about this, they are thinking that those conditional powers would be quite narrow. So, for example, they might be limited to confirmation of the CPO once an aligned stopping up order is confirmed, that sort of thing. I don't in a million years see it as being a situation where you can just park viability to after.
No. I agree. I think suggesting that it was reliant on a 62% increase in values, and that was perhaps before looking at increased labour costs, increased construction costs as well at that time.
And I don't find it surprising that the inspector was unimpressed by the plea coming from the acquiring authority that actually this point had only been raised you know, at the last minute by objectors. It's for the acquiring authority to be satisfied when they are invited to make the CPO and to resolve to make the CPO, that, you know, all the ingredients are there. You know, and that's the point too, where you'd expect the acquiring authority to be saying, where's the relocation strategy? Where's the acquisition strategy? And I would expect the officers of the council to be, you know, named people to be identified who residents and business owners could talk to. It's quite important that the people affected have a relationship with the acquiring authority, and that they are not expected to just go into bat with the developer, as I think really happened here.
Yeah.
Just on that point as well, John, I think another interesting thing that's tied in exactly with what Mary's saying, the inspector picked up on, is that the development agreement between the developer and the acquiring authority was very developer friendly. So actually the acquiring authority had no ability to interfere with what was going on in terms of viability, in terms of saying, well, you know, how are these things working, and also deciding whether or not the scheme progressed. So it was down to the developer whether the scheme progressed, and I think that was a concern of the inspectors, and was just one other reason why she decided not to confirm the CPO.
So it comes back to things like indemnity agreements, etc., and making sure that they're all worded appropriately as well. There's a question, sort of a point that Raj made around the proposed data room exercise that I think David Elving, KC, put forward. But what about the sort of concerns that I think were raised by the promoting authority or the developer around the commercial sensitivity of the you know, providing an up-to-date viability assessment? It doesn't seem
wash, does it really?
Wash, no,
it's not very convincing. No, we just come back to the point that you would expect the acquiring authority to satisfy themselves in relation to viability. And we need to remember that CPOs are made against rising markets, falling markets, and you need to have regard to these things. But it all smelt as if the reason they hadn't done the deals was because actually the developer didn't really want to put his hands in his pockets. And I say the developer, we weren't really talking about a developer. We were talking about a fund that had really just acquired a shopping centre. Yeah, worse.
Probably one for Colin, or John, perhaps. The point around increased landowner engagement and the sort of suggestion that the greater efforts need to be made to help to relocate businesses. Obviously, that can lead to increased promotional costs. I guess that could be a concern for promoting authorities. Is it something to be concerned about, or actually does that bring about benefit because it reduces risk and hopefully the number of objections as well?
Well, I think it's a big risk reducer, and I also think if more deals had been done, it would have strengthened the acquiring authority developer's case. There is no better argument over are you committed to a scheme by showing that you're buying properties, that you're acquiring land. Clearly you're committed if you're acquiring land and doing deals. There's no better way of demonstrating that you are making reasonable offers. If you're doing deals with people, you're clearly doing them because you're making reasonable offers. People don't do deals at levels that aren't reasonable. So if you're relocating businesses as part of those deals, you will quite clearly got a decent relocation policy in place. So reaching agreements, doing deals, I think is an excellent way to actually demonstrate that you've got all your ducks lined up and this kind of thing. And that's certainly, there are a number of people here who I advise, and they will all say that I'm constantly driving home the point: do deals. It's a very positive thing. And yes, there are occasions where maybe you feel slightly uncomfortable about the level you're doing the deal at, and nobody's suggesting you do bad deals. But in terms of risk, in terms of making sure that you don't have the kind of thing that happens at Vicarage Field happen, it's a good idea. And I've been acquiring land for regeneration CPOs for 25 years, and I've never done an early deal that I didn't look back on after it'd been done, sort of a couple of years later, and think, glad I did that deal. That was a good deal at the time. Even if we were, even if at the time you were umming and ahhing about it, should we do it? the benefit of hindsight, every single time it's a deal worth doing.
And in terms of the availability of funding, which sometimes can be an issue at an earlier stage, but doing option agreements or conditional agreements is another option, isn't it? That's something that I don't get the impression was considered here, but it's something that works.
Yeah, no, I mean, I think it what it does is it helps to create some certainty for both parties, because it creates certainty for your acquiring authority, but it also can feed into some of the not less than compensation payments that I talked about earlier. So I think you're absolutely right. There's clear benefits for both parties, and certainly my reading of the documentation that those kinds of arrangements weren't put on the table, which given the sort of funding situation that appears to exist is quite surprising, because I think that's your next best opportunity post an outright acquisition.
Yeah, could be another one for Colin or John, just around PCEs. Raj mentioned the potential maybe for greater scrutiny of property cost estimates. I mean, by their nature, they are estimates. How much reliance should be placed on them? How robust are they at the sort of pre-application stage? I don't know if Colin or John, you've got a view on anything around that. Sorry, it's a bit of a curveball. I've not teed you up for that one.
No, but I mean, probably cost estimates are. I mean, they're very important. Obviously, when you're starting off with a project and you know less about what's going on the ground, there is always a degree of estimation, and as you go through and start speaking to people about their individual claims, they get more accurate. However, it's very important that they are as robust as they can be, and it is also very important that they take into account risk. And I think one of the concerns the inspector had in this particular CPO was that there was no allowance for the risk of extinguishment.
Yeah.
And I know Barking very well. It's actually, although it's quite a deprived area, the central part of it is very well occupied. So, I'd like to think if I had been doing it, the risk of extinguishment would have been on my radar, and I would have reflected something for that. So, probably cost estimates are very important. In terms of their possible future scrutiny at a public inquiry, I think that's always going to be a problem, because you don't want landowners and claimants knowing what estimates you've got against their property. Yeah. But I think you probably can talk about in global terms about the funds you've got available. You probably can, in a secure way, share some information with the inspector without sharing it with the wider public. And I think, we're going to see, after Vicarage Field, we're going to see claimants, landowners putting more pressure on these kinds of things, on viability assessments, on PCEs, on have you got interest in your new scheme? Because that was another issue that the inspector raised, that there didn't seem to be, she didn't think there was sufficient evidence of onward lettings and sales for occupiers of the new development. So I think we could expect to see that, but I don't think we need to be necessarily worried about it. We just have to put in place strategies about how we can deal with it, and it's all doable.
And I suppose if we're offering not less than figures, to some extent, people have got an idea of what sort of number you've got in your PCE as well. So I suppose that's something else to bear in mind. Raj, just in terms of, or Mary, in terms of the delays and the 3-year period between the resolution to make and the actual making, I mean, are there lessons that can be learned there, apart from don't spend that length of time between the two stages? But could perhaps have been a 2-stage resolution approach? Is that an option? What else can be done to avoid that criticism?
Personally, I found it very strange. They didn't refresh the resolution, the 3-year-old members' resolution, but then just goes to making the CPO. That's pretty much, I've never seen anything like that. A week, 2 weeks would be typical.
I agree.
It's clearly about money.
Yeah.
They developed it on push button, they didn't have it. And, it's like to go ahead, and then they saw their planning commission was about to run out and decided to roll the doors. So that's how it worked to me anyway.
It's not unusual, is it, to have an early resolution as a backdrop to negotiations? That's absolutely routine.
Yeah.
But you don't sit there and then rely upon it. You go back. Once you've got your permission, once you've got your development agreement, you go back and you get a more specific resolution and supported by a comprehensive statement of reasons.
Yeah.
And I don't know why they didn't do that.
No, it struck me that that was something that seemed a fairly obvious thing perhaps to have done.
I mean, I
So,
think
yeah.
the truth is they knew that they were up against it because they knew that the planning permission was likely to expire, and they'd only put in one reserve matters application. So they were up against
Push the button. Just before I open up the questions to the floor, is there any gossip, although we think it probably isn't a massively surprising decision, is there any gossip about potential judicial reviews? Anything, any other panelists got anything on that? Maybe not.
Well, I think we do know that a pre-action protocol letter was sent,
Right.
which had a 800-page appendix to it, apparently. Whether that was all the evidence that they wanted to have put in, but they didn't put in, I don't know. But
right.
We also know that they didn't, in fact, lodge a claim. So we know that the decision is not being challenged.
Okay. Okay, that's helpful. Are there any questions from the floor? Oh, yes. Right, I can see a couple of hands have gone up. So.
Hi, can you, hopefully this is working over there, yeah. I'm interested in the costs implications for the council and or for the developer as a result of the refusal. I don't know whether you'd be able to outline what the possible situations might be for the council and or the developer as a result of the decision now being refused. Because you mentioned, Paul mentioned earlier on, it was quite a finely balanced decision. And obviously there was a compelling case in principle for the regeneration, but viability has meant it's got refused along with potentially the negotiation elements, but the consequences of a refusal does have cost implications as well. So I wonder if we just talk about the possibilities there.
I mean, I don't know the precise detail of the development agreement, but presumably I'm guessing that the whole arrangements were structured around a particular planning permission. But they might not have been. They may have set this up so that they could have altered the scheme. One of the things I always try and do when I'm running CPOs is ask myself, absent the CPO, what's the position? Because I think it's always really helpful to remind the decision maker of what won't be achieved absent the CPO. When you say there are sort of wasted costs, that comes back to, does the development agreement indemnify the council in a world where the CPO is not confirmed? And perhaps when the council is entering into a development agreement, knowing that a developer has already said the development's unviable, they would have been very wise to have got a guarantee that their costs would have been recompensed in a win or lose situation. And
also I was thinking about objector costs as well. In that situation and how that might play out. Because obviously it was on the basis of viability. But what then happens? You've got 65 outstanding objectors at the point that the inquiry was made. Well, I would expect all of these successful objectors to be submitting costs applications and to be effectively being awarded their costs because they have succeeded. And so it is quite common in fairly routine, I would suggest, unlike planning appeals, where in planning appeals you only get your costs if the council's behaved unreasonably and you can demonstrate that that's caused you wasted costs. In a CPO where you object and you are successful, you can expect your costs. So again, it comes back to the development agreement that the council has entered into with the developer, because I very much hope that Barking and Dagenham will not have to bear those costs. I would expect them to be able to go back to the fund.
Pretty poor indemnity agreement.
Indeed.
Pretty clear takeaway for local authorities to make sure the development agreement covers them appropriately. Yeah. Okay. There was another question as well, I think. Yeah.
Liz Neat from Deloitte. Raj highlighted 3 schemes that didn't go ahead. I think they're all retail schemes, and they were all inspector recommendation and Secretary of State decision. So I have a sort of, my invitation to the panel is to speculate whether this decision might have been different if it was ultimately the Secretary of State that decided, i.e. whether political will might have changed that. And that's probably a bit of fun because no one really knows. But the slightly more serious question is, I guess, about implications for future decisions, and if inspectors are looking at them, whether they're less likely to be able to rely on the sort of hope of something changing that some schemes have done previously.
I mean, I thought in many ways it's a good decision, but one that seemed to be by a relatively inexperienced inspector in terms of CPOs. There's quite a lot of the guidance she thought were pass fail tests, but wouldn't necessarily. I think if that had gone back to the Secretary of State, there would have been quite a bit of delay, and they would have run out of time for putting their reserve matters in. But it would have been scrutinised by the government legal team, probably with with council looking at it as well, before a decision was made. I suspect it would have been the same decision. I think it would have been very hard to overturn that decision on the viability basis. Might have had better luck on the engagement, but in viability, I just don't think they had a chance.
I completely agree with you, Raj. There was another CPO that was not confirmed, which was quite celebrated at the time, which is the Croydon Gateway CPO. And if you remember, Croydon were adamant that they wanted an arena on a site right by the station, and I was acting for the landowner who had a office-led regen scheme, and we were able to demonstrate to the CPO inspector that it wasn't viable. It wasn't viable to buy a site with the permission for an office-led regen in order to fund an arena, and that CPO failed. And so there have been some singularly some occasions where it fails on viability, and I don't think it would have made any difference at all if it had been a Secretary of State decision. I think more interesting is Shepherd's Bush was another CPO where the inspector, funnily enough, Ava Wood, the same inspector as the Croydon Gateway CPO, she recommended against, and she didn't think that the market traders had been treated particularly well, and the Secretary of State said, no, I disagree with the inspector, I'm going to confirm the CPO. Then the CPO was quashed because guess what? The Secretary of State didn't explain his reasons properly. And so in the end, there was no CPO. Yes, indeed, or at all. In the end, there was no CPO. So that's one of the other things, even if you want for political reasons to confirm the CPO, you've actually got to have very good reasons for disagreeing with an inspector. It's hard to see what those reasons could be in the face of no real evidence that the scheme was viable.
Excuse me, any further questions? No. Or other? No. Okay. I guess an obvious other question is probably whether or not, if it was viable, would it still have failed on the grounds relating to landowner engagement? I suspect maybe it wouldn't just on those grounds alone, but it definitely sort of serves to demonstrate to future promoting authorities that you need to take the guidance very, very seriously. I guess we'll never know whether it would have failed if it was just that element that was a struggle. As I mentioned at the outset, it's a decision that obviously has raised a lot of eyebrows and also resulted in us sort of having lots of lessons to learn from it. And I think hopefully you'll agree with me that the speakers and the panelists have really helped to present those points very clearly to us. So if you could thank them in the traditional way. Thank you. And also thanks to Mark Barlow and CPT for facilitating the event and the recording as well. And most importantly, thanks again to all of you for coming out and joining us here tonight. Hopefully as many of you as possible can join us for a drink afterwards, and I'll catch up with you over the next half an hour or so. So thank you very much.